On March 7, 1965, approximately 600 people began walking across the Edmund Pettus Bridge in Selma, Alabama. They were marching to Montgomery, the state capital, to demand the right to vote. Most of them were black. All of them were American citizens. All of them were constitutionally entitled to vote under the 15th Amendment, which had been part of the Constitution since 1870. And essentially none of the black adults in Dallas County, Alabama, where Selma was located, were registered to vote, because the state of Alabama had spent 95 years systematically preventing them from doing so. At the foot of the bridge, on the other side, state troopers and county sheriff's deputies were waiting. When the marchers reached them, the troopers put on gas masks, drew their clubs, and attacked. They beat the marchers with clubs and bullwhips. They fired tear gas. They rode horses into the crowd. 17 people were hospitalized. The images were broadcast on national television that evening, interrupting a broadcast of Judgment at Nuremberg, a film about Nazi war crimes, to show American law enforcement beating American citizens who were trying to exercise their constitutional right to vote. The images produced what the civil rights movement had been trying to produce for years, a national political crisis that the federal government could not ignore. 8 days later, President Lyndon Johnson addressed a joint session of Congress and declared that the United States must overcome the crippling legacy of bigotry and injustice. He concluded his speech with the words of the civil rights movement itself: "We shall overcome." The Voting Rights Act was signed on August 6, 1965, 5 months after Bloody Sunday on the Edmund Pettus Bridge. It was the most significant voting rights legislation since the 15th Amendment, and it was designed to do something the 15th Amendment had conspicuously failed to do: actually enforce the right to vote for black Americans in the states that had spent 95 years refusing to recognize it. The 15th Amendment, ratified in 1870, stated that the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. The language was clear, the enforcement was not. Between 1870 and 1965, the southern states developed and deployed a system of voting restrictions that were technically race-neutral, but that were designed, administered, and enforced in ways that almost entirely excluded black voters while leaving white voters largely unaffected. The mechanisms of this system are specific, documented, and instructive because they were legal, because they were sustained by the federal courts for decades, and because understanding them is essential for understanding what the Voting Rights Act actually had to overcome. The poll tax was the oldest and most straightforward mechanism. A tax levied on the act of voting, typically around $2 per election, was required to be paid before a person could cast a ballot. $2 does not sound like much, but in the rural South of the early 20th century, $2 represented a significant fraction of a poor agricultural worker's daily wages, and the cumulative poll taxes for multiple elections could amount to a substantial financial barrier for someone who had been disenfranchised for years and wanted to register to vote. The poll tax was race-neutral on its face. It applied to white voters as well as black voters. But its administration was not neutral. White voters who could not afford the poll tax were often assisted by local Democratic Party organizations or by sympathetic registrars who found ways to waive or defer the requirement. Black voters who could not afford it had no such assistance and faced strict enforcement. The 24th Amendment, ratified in 1964, prohibited the poll tax in federal elections. The Supreme Court's decision in Harper v. Virginia Board of Elections in 1966 extended the prohibition to state elections. The literacy test was the most flexible and most abused mechanism. Registration to vote in most southern states required passing a literacy test, demonstrating the ability to read and interpret a section of the state or federal constitution to the satisfaction of the county registrar. The test was administered by the registrar, who had complete discretion over what question to ask, what answer to require, and whether the applicant's performance was satisfactory. In practice, the literacy test was administered in ways that made it essentially impossible for black applicants to pass, and essentially impossible for white applicants to fail. Black applicants with college degrees were asked to explain obscure constitutional provisions and failed when their explanations were deemed insufficient. White applicants who were barely literate were asked simple questions and passed without difficulty. The subjectivity of the test was entirely the point. It gave the registrar the power to make any decision about any applicant without any objective standard that could be challenged in court. The grandfather clause, which several southern states used in the early 20th century, exempted from literacy and other requirements any voter whose grandfather had been eligible to vote before the Civil War. Since black men had been enslaved before the Civil War and could not vote, their grandsons were not eligible for the exemption. White men, whose grandfathers had voted before the war, received the exemption automatically. The Supreme Court struck down grandfather clauses in Ginn v. United States in 1915, but the other mechanisms continued. The white primary was a mechanism specific to the one-party South, where winning the Democratic primary was the equivalent of winning the election. Southern states and Democratic Party organizations excluded black voters from participating in Democratic primaries, arguing that the primary was a private party function rather than a public election and therefore not subject to the 15th Amendment's prohibition on racial discrimination in voting. The Supreme Court repeatedly wrestled with white primary cases, striking down various forms of it in different decisions until Smith v. Allwright in 1944 finally held that the white primary was unconstitutional regardless of how it was structured. The purging of voter rolls was another mechanism used to remove black voters who had managed to register from the rolls by claiming that they had moved, failed to vote in recent elections, or committed some technical violation of the registration requirements. The purges were applied selectively, removing black voters while leaving white voters on the rolls even when they had not voted for years. Violence and economic intimidation were the mechanisms that undergirded all the others. A black sharecropper who attempted to register to vote might find their landlord demanding they pay their rent immediately, or find themselves unable to renew their tenancy, or receive a visit from members of the Ku Klux Klan, or simply be told by the people who controlled their economic survival that registering to vote would have consequences they could not afford to face. The formal legal mechanisms were backed by informal mechanisms of terror that made the formal ones largely unnecessary in many communities. The result of this system was the near-total disenfranchisement of black voters across the South, lasting from the end of Reconstruction through the passage of the Voting Rights Act. In Mississippi, where black residents constituted approximately 42% of the population in 1964, only 6.7% of eligible black voters were registered. In Alabama, it was approximately 19%. In Louisiana, approximately 32%. Across the South, the registration rate for black voters was a fraction of what it would have been in the absence of the systematic suppression that had been in operation for nearly a century. The human consequences of this disenfranchisement extended far beyond the inability to cast a ballot. Voters elect the people who make decisions about schools, roads, law enforcement, courts, and every other dimension of public life. Communities whose members cannot vote are communities whose political interests are systematically unrepresented in the decisions that affect their lives. The black communities of the South, denied the vote for nearly a century, received public services, infrastructure, schools, and legal protections that reflected the political priorities of white voters and white office holders rather than the needs and interests of the black communities that were being governed without their consent. The civil rights movement's focus on voting rights was not incidental to its other goals. The movement's leaders understood that voting rights were the foundation of political power, and that political power was the prerequisite for addressing the economic inequality, the educational inequality, the legal inequality, and the social inequality that characterized the Jim Crow South. You could march for better schools, but without political power, you could not elect the officials who would fund them. You could demand fair wages, but without political power, you could not elect the legislators who would enact labor protections. Voting rights were the lever that could move everything else. The legal strategy for challenging voting rights restrictions predated the Voting Rights Act by decades. The NAACP had been litigating voting rights cases since its founding, winning the Grandfather Clause case in 1915, and the white primary cases culminating in Smith v. Allwright in 1944. These legal victories were significant but insufficient because the states simply developed new mechanisms to replace the ones that had been struck down. Every time the courts eliminated one restriction, the states invented another, keeping the system of exclusion operational even as its specific legal forms changed. The political strategy developed alongside the legal strategy. The NAACP and other civil rights organizations organized voter registration drives, supported black candidates for local office in the few jurisdictions where black voting was permitted, and built the political infrastructure that would be ready to mobilize when voting rights were secured. The Student Nonviolent Coordinating Committee made voter registration in the Deep South one of its primary activities in the early 1960s, sending young organizers into the most dangerous counties in Mississippi, Alabama, and Georgia to help black residents attempt to register despite the violence and economic retaliation that such attempts typically provoked. The Freedom Summer of 1964, in which hundreds of college students, most of them white, traveled to Mississippi to help with voter registration and education, was designed partly to increase the visibility of Mississippi's systematic exclusion of black voters. The organizers understood that the deaths of Michael Schwerner and Andrew Goodman, who were white, would attract national attention that the deaths of black civil rights workers like James Chaney had not attracted. The tactic was cynical in its acknowledgement of the racial double standard in American media attention, but it was effective. The Freedom Summer murders generated national coverage and contributed to the political momentum for the Civil Rights Act of 1964 and subsequently for the Voting Rights Act. The Selma marches of early 1965 were the final political catalyst. The murder of Jimmy Lee Jackson by a state trooper during a voting rights march in Marion, Alabama in February 1965 prompted the decision to march from Selma to Montgomery. The Bloody Sunday attack on the Edmund Pettus Bridge on March 7th, broadcast nationally, produced the crisis of political legitimacy that finally forced federal action. The Voting Rights Act of 1965 was different from the civil rights legislation that preceded it because it had actual enforcement mechanisms. Previous civil rights legislation had relied primarily on litigation, requiring individuals or the Justice Department to sue to enforce rights that were being violated. The Voting Rights Act established a preclearance requirement. States and localities with histories of voting discrimination were required to obtain approval from the Justice Department or the Federal District Court in Washington before making any change to their voting laws. The preclearance requirement meant that states could not simply invent new discrimination mechanisms to replace the ones the court struck down, because any new mechanism required federal approval before it could go into effect. The act also authorized federal examiners to register voters directly in jurisdictions where local registrars were refusing to register eligible voters, eliminating the local registrar as a gatekeeper. And it prohibited the specific mechanisms, including literacy tests and other devices, that had been used to exclude black voters in the covered jurisdictions. The effect was immediate and dramatic. Black voter registration in the South increased by millions within months of the act's passage. In Mississippi, black voter registration went from 6.7% to 59.8% within 4 years. In Alabama, it went from 19.3% to 61.3%. Black candidates won elections for local offices that had been exclusively white for a century. The political landscape of the South began to change in ways that the civil rights movement had been working toward for decades. The Voting Rights Act was reauthorized by Congress multiple times in 1970, 1975, 1982, and 2006, each time with bipartisan support that reflected the broad consensus that the Act's protections were necessary. The 2006 reauthorization passed the Senate 98-0 and the House 390-33, reflecting the political reality that opposing the Voting Rights Act was essentially untenable even for members of Congress who were skeptical of other civil rights legislation. The Supreme Court's 2013 decision in Shelby County versus Holder struck down the formula that determined which states and localities were subject to the preclearance requirement, effectively gutting the preclearance mechanism by leaving it without the coverage formula that identified which jurisdictions were required to seek approval for changes to their voting laws. The majority opinion, written by Chief Justice John Roberts, held that the coverage formula was based on historical data from the 1960s and 1970s that no longer reflected current conditions, and that Congress needed to update the formula to reflect contemporary evidence of discrimination before the preclearance requirement could constitutionally continue. The dissent, written by Justice Ruth Bader Ginsburg, argued that the majority was removing the umbrella because it was not raining, ignoring the fact that the preclearance requirement was the reason it was not raining. The historical evidence of voting discrimination that the preclearance requirement was preventing was not visible precisely because the preclearance requirement was preventing it. The Shelby County decision had immediate practical consequences. Within hours of the decision, Texas announced that it would implement a voter ID law that had previously been blocked under the preclearance requirement, and the state's new district maps, also previously blocked, would go into effect. Over the following years, states that had been subject to preclearance implemented a range of voting restrictions, including voter ID laws, reductions in early voting, elimination of same-day registration, restrictions on voter registration drives, and purges of voter rolls, that would have required federal approval under the preclearance requirement and that might not have received that approval. The current state of American voting rights is contested in ways that echo the contested state of the late 1950s, before Bloody Sunday and before the Voting Rights Act. The mechanisms of restriction are different, no longer the explicit poll taxes and literacy tests of the Jim Crow era, but the effects on participation rates in specific communities are measurable. Voter ID laws that require specific forms of identification that lower-income voters are less likely to possess disproportionately affect Black and Hispanic voters. Reductions in polling places in communities of color produce longer lines and greater difficulty voting. Strict voter roll purges remove eligible voters who have not recently voted from the registration rolls. The legal and political battles over these contemporary restrictions are the continuation of the century-long battle over voting rights that the Voting Rights Act of 1965 was supposed to resolve. They are being fought in federal courts, in state legislatures, in congressional debates over the John Lewis Voting Rights Advancement Act, which would restore and update the preclearance requirement, and in the broader political culture over what voting should look like in a democratic society. Understanding the history of how the systematic disenfranchisement of Black voters was built and maintained, and of what it took to dismantle it, is essential for evaluating the contemporary voting rights debates honestly. The mechanisms are different. The fundamental question, whether the government will take the specific steps necessary to ensure that all eligible citizens can actually exercise the right to vote, is the same, from the 15th Amendment of 1870 that declared the right to vote. To the 95 years of systematic mechanisms that made that declaration meaningless for Black Americans in the South. To the Voting Rights Act of 1965 that finally enforced the constitutional right. To the Shelby County decision of 2013 that weakened the enforcement mechanism. To the ongoing battles over contemporary voting restrictions that echo the battles of the pre-1965 era. That is the history of voting rights in America. The constitutional right was declared in 1870. It was not effectively enforced until 1965. Its enforcement has been weakened since 2013, and the question of whether all eligible Americans can actually exercise the right to vote remains actively contested. Subscribe if this kind of history is what you are here for. There is a great deal more of it ahead. To understand the full scope of what the disenfranchisement system accomplished over its 95-year operation, you need to trace its effects beyond the individual act of being denied registration and into the broader consequences for Black communities across the South. The connection between voting rights and every other dimension of civic life in the American system is not incidental. The American system of government, from the local county commission to the state legislature to the federal Congress, is designed around the premise that elected officials are accountable to their constituents through the electoral process. Officials who want to remain in office must respond to the preferences and interests of the voters who elect them. Officials who do not respond to those preferences can be removed. In the Jim Crow South, Black residents were constituents who could not vote. The officials who governed them had no electoral accountability to them whatsoever. The sheriff who enforced the law in Dallas County, Alabama, did not need Black voters' approval to keep his job. The county commissioners who funded the schools did not need Black voters' approval to allocate resources between white schools and Black schools. The state legislators who wrote the laws did not need Black voters' approval to determine what those laws would be. The consequences of this accountability gap were visible in every dimension of public life. Black schools in the segregated South received a fraction of the per-pupil funding that white schools received, because the officials who made funding decisions were accountable only to white voters who had no interest in equal funding for Black schools. Black communities received inferior roads, inferior water and sewage systems, inferior public facilities of every kind, because the officials responsible for these services were accountable only to voters who were not members of those communities. The legal system was particularly stark in its accountability gap. The sheriffs, prosecutors, and judges who administered justice in the South were elected by and accountable to white voters. The juries that decided cases were drawn from voter rolls that excluded Black citizens. The result was a legal system that protected white citizens and systematically failed Black citizens, not because of some incidental racial bias, but because the institutional structure of the system built racial bias into its accountability mechanisms. The Black citizens of Dallas County, Alabama, who were marching across the Edmund Pettus Bridge on March 7, 1965, were marching for more than the ability to cast a ballot. They were marching for the accountability that the ballot provides. They were marching for schools that were funded adequately. They were marching for roads that were maintained. They were marching for police who were accountable to the communities they policed. They were marching for the legal system that was supposed to protect them rather than systematically fail them. All of these things required voting rights, because without voting rights, there was no mechanism through which Black communities could hold officials accountable for the conditions of their schools, their roads, their legal system, and their lives. The registration drives that preceded the Selma marches were not simply administrative exercises in completing government forms. They were acts of political courage in communities where attempting to register could cost a person their job, their tenancy, their physical safety, or their life. The civil rights workers who organized voter registration drives in Mississippi and Alabama in the early 1960s were organizing in communities where the local power structure was committed to maintaining the disenfranchisement system by any means necessary, including violence. The specific cases of retaliation against Black citizens who attempted to register to vote are documented in detail in the congressional hearings and the Justice Department investigations that preceded the Voting Rights Act. A tenant farmer in Mississippi who went to the county registrar to attempt to register to vote was evicted from his land within days by the white landowner who learned of the attempt. A school teacher in Alabama who led a group of students to the registrar's office to watch the registration process was fired from her job the following week. A business owner in Georgia who publicly encouraged Black residents to register to vote found his credit at the local bank suddenly recalled. These were not isolated incidents. They were the systematic operation of a social and economic control system that used the threat of economic and physical harm to enforce the political exclusion that the legal mechanisms of disenfranchisement established. The literacy test was the visible legal mechanism. The threat of eviction, job loss, and violence was the invisible enforcement mechanism that made the literacy test work. Understanding both dimensions of the disenfranchisement system is essential for understanding why the Voting Rights Act needed to include the specific provisions it contained, and why litigation alone had been insufficient to address the problem. You could litigate and win against the grandfather clause, and the states would replace it with the white primary. You could litigate and win against the white primary, and the states would strengthen the literacy test. You could litigate and win against specific administrations of the literacy test, and the states would train their registrars to administer it in ways that were harder to challenge. The pre-clearance requirement addressed this adaptive quality of the disenfranchisement system by requiring advance approval for any change, rather than waiting for a discriminatory change to be implemented and then litigating against it. This was a fundamentally different approach to enforcement, preventive rather than reactive, structural rather than case-by-case. The effectiveness of the pre-clearance requirement was demonstrated repeatedly in the years after the Voting Rights Act's passage. The Justice Department objected to hundreds of proposed changes to voting laws and procedures in the covered jurisdictions, blocking implementation of changes that would have reduced black voting participation. Without the pre-clearance requirement, these changes would have been implemented, litigated after the fact if at all, and in many cases permitted to remain in effect for years while litigation proceeded. The argument that the Roberts Court majority made in Shelby County, that conditions had changed enough since the 1960s that the pre-clearance formula was no longer justified, was an empirical claim that was contested by the evidence that the court itself had acknowledged in its opinion. The court recognized that voting discrimination had been reduced significantly since the 1960s, but the evidence also showed that covered jurisdictions continued to propose discriminatory voting changes at higher rates than non-covered jurisdictions, and that the pre-clearance requirement was the reason those changes were being blocked before they could be implemented. The post-Shelby County experience confirmed the dissent's warning. The wave of voting restrictions that followed the decision, implemented by states that had previously been subject to pre-clearance, produced measurable reductions in voter participation in specific communities. Voter ID laws in states like Texas and North Carolina reduced registration and turnout among black and Hispanic voters. Poll place closures in communities that had been covered under the pre-clearance requirement increased wait times and reduced participation. Aggressive voter roll purges removed eligible voters who had not recently voted. These effects were documented by researchers, litigated by civil rights organizations, and in some cases found to violate the remaining provisions of the Voting Rights Act that the Shelby County decision had not struck down. The Fourth Circuit Court of Appeals, in striking down North Carolina's omnibus voting restrictions in 2016, found that the restrictions targeted African Americans with almost surgical precision, deliberately designing restrictions to hit the specific voting mechanisms that black voters used at higher rates than white voters. The North Carolina case illustrated that the mechanisms of voting restriction had evolved since the Jim Crow era, but that their purpose had not. The specific restrictions were designed to reduce black voter participation without explicitly referencing race, using the statistical knowledge of which voting mechanisms different racial groups used to craft restrictions that would have disparate racial effects while maintaining formal race neutrality. This is the same logic that produced the literacy test in the first place, a formally race-neutral mechanism administered in a racially discriminatory way to produce racially discriminatory outcomes. The specific mechanism has modernized. The underlying logic has not. The John Lewis Voting Rights Advancement Act, which would restore and update the pre-clearance requirement with a new coverage formula based on contemporary evidence of voting discrimination, has been introduced in Congress multiple times without passing, blocked primarily by Republican opposition in the Senate. The political debate over the act reflects the same fundamental disagreement that has characterized voting rights debates since Reconstruction. Whether the federal government has the obligation to actively ensure that all eligible citizens can actually exercise the right to vote, or whether the formal existence of the right is sufficient without active federal enforcement. The history of what the formal existence of the right without active enforcement produced, 95 years of systematic disenfranchisement that was fully consistent with the formal existence of the 15th Amendment, provides the answer to this question as clearly as any historical evidence can. The formal right without enforcement is not a right. It is a promise without accountability. From the 15th Amendment of 1870, to the systematic mechanisms of disenfranchisement that operated for 95 years within its formal constraints, to the Voting Rights Act of 1965 that finally enforced the right, to the Shelby County decision that weakened the enforcement, to the contemporary restrictions that echo the mechanisms of the Jim Crow era in their design and their effects. That is the history. The right was declared, the enforcement has been contested. The question of whether the federal government will maintain the active enforcement that makes the right real is being answered right now, in the courts, in Congress, and in the state legislatures that are designing the voting restrictions of the present era. Subscribe if this kind of history is what you are here for. There is a great deal more of it ahead. The international context provides an important perspective on the American voting rights story, because the United States is not the only democracy that has struggled with the question of whether all its citizens can actually exercise the right to vote. South Africa's transition from apartheid to democracy in 1994 required not just the extension of voting rights to black South Africans who had been excluded from the franchise, but the construction of an entirely new electoral system that could accommodate the participation of millions of first-time voters. The logistical and institutional challenges of this transition were enormous, and the fact that South Africa managed it successfully in 1994 was a remarkable achievement. The comparison is instructive for the American voting rights story because it illustrates the gap between the Declaration of Voting Rights and the actual capacity of a political system to include all its citizens in the exercise of those rights. South Africa's transition required not just legal change, but institutional investment in the capacity for previously excluded groups to actually vote. The American Voting Rights Act represented a similar investment in the specific sense of deploying federal resources, federal examiners, and federal oversight to ensure that the legal change represented by the Act was actually implemented in practice. The Act was effective because it combined legal prohibition with active enforcement, recognizing that legal prohibition without enforcement produces the same result as no prohibition at all, which is what 95 years of experience with the 15th Amendment had demonstrated. Australia's compulsory voting system provides a different point of comparison. In Australia, voting is legally required, and citizens who do not vote without an approved reason can be fined. The compulsory voting system produces voter turnout rates of approximately 90%, compared to turnout rates in American elections that rarely exceed 60% for presidential elections and are often much lower for midterm and local elections. The American political culture's resistance to compulsory voting reflects the same emphasis on individual freedom and resistance to government mandate that has shaped many aspects of American social policy. Whether compulsory voting would produce better democratic outcomes in the American context is a contested question. What is clear is that the American voluntary voting system, combined with the barriers to voting that have been built into the administrative system, produces significantly lower participation rates than comparable democracies, and that the participation gap is not randomly distributed across the population. The voters who are least likely to participate in American elections are disproportionately lower income, younger, and racial and ethnic minorities. These are precisely the populations whose political interests are most often underrepresented in the policy outcomes of American democracy. The correlation between low participation and underrepresentation in policy outcomes is not coincidental. It is the mechanism through which the failure to ensure actual exercise of voting rights produces policy outcomes that fail to represent the full range of the population's interests. Canada, the United Kingdom, and most European democracies use automatic voter registration, in which eligible citizens are automatically enrolled in the voter rolls rather than having to take affirmative steps to register. The American system of opt-in voter registration, in which eligible citizens must affirmatively register before they can vote, creates a barrier to participation that does not exist in these other democracies. The voter registration requirement has historically been used as a mechanism of voter suppression, as the history of literacy tests, registration purges, and discriminatory registration procedures demonstrates. The shift to automatic voter registration would eliminate this mechanism, ensuring that all eligible citizens are registered without requiring them to navigate an administrative system that has historically been used against them. Several American states have adopted automatic voter registration in recent years, producing measurable increases in registration rates and in voter turnout. The evidence from these states supports the claim that automatic registration increases participation without producing the fraud that opponents predict. But the federal adoption of automatic voter registration has not been achieved, and the states that have adopted it are not evenly distributed across the political landscape. The international comparisons suggest that the American voting system, while formally democratic, produces lower rates of actual participation than comparable democracies, and that this lower participation is systematically distributed in ways that underrepresent specific communities. Addressing this requires not just legal protection against overt discrimination, but affirmative investment in the administrative infrastructure that makes voting actually accessible for all eligible citizens. The Voting Rights Act of 1965 was an affirmative investment in accessibility, deploying federal resources to ensure that formal rights were actually exercised. The weakening of the Act's enforcement mechanism since 2013 has reduced this affirmative investment, and the consequences are visible in the voting patterns of jurisdictions that were previously covered by pre-clearance. Whether the United States will restore and strengthen its affirmative investment in voting rights enforcement depends on the political conditions that are being created now by the civil rights organizations that are litigating voting restrictions, by the advocates who are pushing for the John Lewis Act, by the voters who are deciding whether voting rights enforcement is a political priority, and by the elected officials who will ultimately make the legislative and administrative decisions that determine what voting looks like in the United States going forward. From Bloody Sunday in 1965 to the Voting Rights Act signed 5 months later. From the systematic disenfranchisement that preceded it to the systematic enforcement that followed it. From the Shelby County decision that weakened the enforcement to the contemporary restrictions that have followed. The history of voting rights in America is not a history that has reached its conclusion. It is a history that is still being made in the same battleground states, often the same counties, where the battles of the 1960s were fought. Subscribe if this kind of history is what you are here for. There is a great deal more of it ahead. There is a final dimension of the voting rights story that connects the historical disenfranchisement to the present moment in ways that are important for understanding both what was achieved and what remains at risk. That dimension is the relationship between voting rights and political representation, and specifically the question of what black political representation looked like before the Voting Rights Act and what it looked like after. Before the Voting Rights Act, black political representation in the South was essentially zero at every level of government. There were no black members of Congress from southern states. There were no black governors or lieutenant governors. There were no black mayors in major southern cities. There were virtually no black county commissioners, no black sheriffs, no black judges, no black state legislators in the states where black residents constituted significant fractions of the population. This was not a coincidence. It was the direct consequence of systematic disenfranchisement. Officials are elected by voters. Voters who are excluded from the electoral process cannot elect officials who represent their interests. The political representation of black Southerners before 1965 was precisely zero because the mechanism for producing political representation, the vote, was systematically denied. After the Voting Rights Act, black political representation began to grow. The first black members of Congress from the South since Reconstruction were elected in the years following the Act's passage. Black mayors were elected in major southern cities. Black state legislators were elected in states that had none. Black judges were appointed and elected. Black county commissioners, sheriffs, and other local officials were elected in communities that had been governed exclusively by white officials for a century. This growth in political representation was not simply a symbolic change. It had concrete policy consequences. School funding in counties with black elected officials increased toward greater equity with white schools. Police departments with black officers and black leadership were more likely to hold officers accountable for misconduct against black residents. Courts with black judges produced more equitable outcomes in cases involving black defendants and black litigants. The accountability gap that systematic disenfranchisement had created was partially closed by the political representation that voting rights made possible. The growth in black political representation since 1965 has been significant, but incomplete. Black Americans remain underrepresented in elected offices at all levels of government relative to their share of the population. The gap is particularly pronounced in executive offices, governorships, and the presidency, where black representation has been historically rare, and in legislative bodies where single-member district systems and gerrymandering can dilute the political effectiveness of black voters even when those voters are not directly excluded from the franchise. The Section 2 of the Voting Rights Act, which the Shelby County decision left intact, prohibits voting practices that result in racial minorities having less opportunity to participate in the political process and to elect representatives of their choice. The application of Section 2 to racial gerrymandering has been one of the most contested areas of voting rights law in recent decades, as courts have struggled to define the line between permissible partisan gerrymandering and impermissible racial gerrymandering in states where race and party affiliation are highly correlated. The Supreme Court's 2023 decision in Allen v. Milligan required Alabama to redraw its congressional district map to create an additional district where black voters had a realistic opportunity to elect a representative of their choice, applying Section 2 to Alabama's attempt to pack black voters into a single congressional district in ways that diluted their political power across the state. The decision was significant as an affirmation that Section 2 retained force in the post-Shelby County environment, though the specific application to Alabama's map had been contested for years through multiple rounds of litigation. The ongoing litigation over district maps in multiple states reflects the continuing effort to translate the formal right to vote into actual political representation, which requires not just the ability to cast a ballot, but an electoral system that translates votes into representatives. The disenfranchisement system of the Jim Crow era worked by preventing votes from being cast. Contemporary mechanisms work by preventing votes from being translated into representation through the tools of redistricting, voter ID requirements that affect participation, and other administrative barriers. The goal of the voting rights movement has always been both the ability to vote and the ability to elect representatives who are accountable to the communities that elect them. The Voting Rights Act addressed the first part of this goal more directly than the second, and the ongoing legal and political battles over redistricting, registration, and administrative barriers reflect the incomplete realization of the second part. From the 95 years of systematic disenfranchisement that produced 0 black elected officials in the South, to the Voting Rights Act that opened the franchise and produced the first black elected officials in a generation, to the ongoing battles over redistricting, voter ID, and the other mechanisms through which political representation is shaped, to the question of whether the federal government will maintain the active enforcement that makes voting rights real. That is the full history. The formal right exists. The active enforcement that makes it real has been contested since the day the Voting Rights Act was signed, and the question of whether American democracy will live up to its stated commitment to equal political participation is still being answered. Subscribe if this kind of history is what you are here for. There is a great deal more of it ahead. The numbers that make this history concrete are worth stating one final time, because they translate the abstract history into the specific human reality of what disenfranchisement and enfranchisement actually produced. In 1964, in Mississippi, 6.7% of eligible black voters were registered. In a state where black residents constituted 42% of the population, black voters were essentially absent from the electorate. The political consequences of this absence were visible in every dimension of public life in the state: the schools, the roads, the legal system, the law enforcement. By 1967, 2 years after the Voting Rights Act, black voter registration in Mississippi had risen to approximately 60% of eligible black voters. By 1970, it had risen further. By 1975, Mississippi had more black elected officials than any other state in the country, reflecting the rapid translation of newly exercised voting rights into political representation. In Alabama in 1965, before the Voting Rights Act, approximately 19% of eligible black voters were registered. Today, black voter registration rates in Alabama are comparable to white voter registration rates, and the state has black representatives in Congress, in the state legislature, and in local governments throughout the state. These numbers represent the transformation that the Voting Rights Act produced. They represent the closing, at least in part, of the accountability gap that 95 years of systematic disenfranchisement had created. They also represent what was at stake in the Shelby County decision and in the contemporary debates about voting restrictions. A voting rights enforcement system that is weakened produces a gradual erosion of the participation rates that the Voting Rights Act achieved. The erosion is less dramatic than the near-total disenfranchisement of the Jim Crow era, but it is measurable, documented, and consequential for the communities where it occurs. The voter who is prevented from casting a ballot by a voter ID law they cannot comply with. The voter who is removed from the rolls by an aggressive purge. The voter who faces a 3-hour wait at a polling place that has been reduced in their community while polling places in nearby communities have not. These voters are experiencing a less extreme but structurally similar form of the same problem that the marchers on the Edmund Pettus Bridge were marching to address. The history of voting rights in America is not a history that ended in 1965. It is a history that the Voting Rights Act advanced significantly, and that has been contested and partly reversed in the decades since. It is a history that is still being made, from the 6.7% black voter registration in Mississippi in 1964, to the 60% registration 2 years after the Voting Rights Act, to the Shelby County decision that weakened the enforcement, to the contemporary restrictions and the ongoing litigation. The right to vote has been declared, denied, enforced, and contested over 2 centuries of American history. The question of whether it will be fully realized for all eligible Americans in all future elections is still open. That is the honest history, and it demands more than it has received. Subscribe if this kind of history is what you are here for. There is a great deal more of it ahead. One more thread of this history deserves attention before we close. It is the thread that connects the specific story of black voting rights to the broader story of American democracy and its ongoing struggle to include all its citizens in the exercise of political power. American democracy has always been defined by a gap between its stated ideals and its actual practice. The Declaration of Independence declared that all men are created equal, while the Constitution protected slavery. The 15th Amendment declared that the right to vote shall not be denied on account of race, while the states of the former Confederacy systematically denied it for 95 years. The Voting Rights Act declared that the constitutional right would be enforced, while subsequent political forces have worked to weaken that enforcement. This gap between ideal and reality is not unique to voting rights. It characterizes American civil rights history more broadly. But voting rights have a specific importance in a democratic system because they are the mechanism through which all other rights are ultimately protected. A community that cannot vote cannot elect officials who will protect its other rights. A community that cannot hold officials accountable through the ballot is at the mercy of officials whose accountability runs elsewhere. The specific history of black disenfranchisement in America illustrates this with particular clarity. The communities that were most severely disenfranchised, the black communities of the rural South, were also the communities that received the worst schools, the most brutal law enforcement, the least legal protection, and the fewest economic opportunities. These conditions were not coincidental with disenfranchisement, they were products of it. The restoration of voting rights through the Voting Rights Act produced measurable improvements in all of these dimensions, not immediately and not completely, but consistently over the decades since the Act's passage. Better schools in counties with black elected officials. More accountable law enforcement in jurisdictions with black political representation. More equitable legal outcomes in courts with black judges. The connections are documented, not assumed. Understanding these connections is essential for understanding what is at stake in the contemporary voting rights debates. When voting rights advocates argue that voter ID laws, polling place closures, and aggressive purges constitute voter suppression, they are not simply making a procedural argument about administrative fairness. They are making an argument about political power and accountability, about who gets to shape the conditions of their own lives through the democratic process and who is governed by officials who are not accountable to them. This is the same argument that the marchers on the Edmund Pettus Bridge were making on March 7, 1965. It is the argument that the Voting Rights Act was designed to answer, and it is the argument that continues to need answering in 2025 as the mechanisms of voting restriction evolve and as the enforcement mechanisms that were designed to address them are contested and weakened, from the marchers on the Edmund Pettus Bridge in 1965, to the Voting Rights Act that answered their argument in law, to the Shelby County decision that weakened the answer, to the contemporary debate about what voting rights enforcement should look like. The argument for full and equal voting rights has been made, won in law, and continues to require defending in practice. That is the state of American voting rights in 2025. Subscribe if this kind of history is what you are here for. There is a great deal more of it ahead. The last word belongs to the Edmund Pettus Bridge, because it is the most concentrated symbol of everything this history has described. The bridge was named after Edmund Pettus, a United States Senator from Alabama who was also a former Grand Dragon of the Ku Klux Klan. The 600 people who walked across it on March 7, 1965 were walking across a bridge named after a man who had devoted a significant part of his life to preventing black Americans from participating in the political system. The symbolism was not accidental. It was the daily reality of the South. The power structure was literally named after people who had enforced exclusion. The marchers crossed the bridge anyway. They were beaten. The images of the beating were broadcast nationally. 8 days later, Lyndon Johnson addressed Congress with the words of the movement. 5 months later, the Voting Rights Act was signed. The bridge still bears Edmund Pettus's name. There is an ongoing debate about renaming it after John Lewis, who was one of the marchers on Bloody Sunday and who went on to serve in Congress for more than 3 decades as one of the most consistent advocates for voting rights in American political history. The debate about the name is itself a debate about how America relates to this history, whether it acknowledges what happened on that bridge, honors those who marched across it, and commits to the ongoing enforcement of the rights they were marching for. John Lewis died in 2020. The John Lewis Voting Rights Advancement Act, which would restore the pre-clearance requirement that the Shelby County decision gutted, has not yet passed Congress. The bridge still bears Edmund Pettus's name. These facts say something about where American democracy stands on the questions that were raised on March 7, 1965, from the bridge in Selma in 1965, to the Voting Rights Act that followed, to the Shelby County decision that weakened it, to the John Lewis Act that has not yet passed, to the bridge that still bears Edmund Pettus's name. That is where this history leaves us. The marchers were right. The law they marched for was necessary. Its enforcement has been contested, and the question of whether American democracy will fully honor what was won on that bridge is still being answered. Subscribe if you want to keep following this kind of history. There is more ahead. The final observation about this history is about what it means that the right to vote, the most fundamental right in a democratic system, required active federal enforcement to become real for millions of American citizens, and what it means that that enforcement has been weakened in recent decades. A right that exists only in law but not in practice is not a right. It is a promise. The history of the 15th Amendment from 1870 to 1965 is the history of a promise that was systematically broken for 95 years by the states that were supposed to honor it. The history of the Voting Rights Act from 1965 to the present is the history of the enforcement mechanism that made the promise real, and of the ongoing political effort to weaken or eliminate that enforcement mechanism. The people who marched across the Edmund Pettus Bridge understood this. They were not marching for a promise. They had the promise since 1870. They were marching for the enforcement that would make the promise real. The enforcement came in the form of the Voting Rights Act. It has been weakened. And the question of whether it will be restored and strengthened is the question that the history of this abridge, this act, and this long struggle demands we answer. From the promise of 1870, to the enforcement of 1965, to the weakening of 2013, to the question of 2025. That is the history of equal voting rights in America. The promise exists, the enforcement has been contested, and the marchers on the Edmund Pettus Bridge deserve better than a bridge that still bears their opponent's name and a law whose enforcement continues to be fought over 60 years after they crossed it. Subscribe if this kind of history is what you are here for. There is more ahead. There is one more set of facts that this history demands be stated plainly, because they connect the abstract history to the concrete reality of what voting rights enforcement means in practice today. Between 2013, when the Shelby County decision was handed down, and 2020, more than 1,600 polling places were closed in states that had previously been subject to preclearance under the Voting Rights Act. The closures were concentrated in counties with large Black and Hispanic populations. In Maricopa County, Arizona, the number of polling places was reduced from 200 in the 2012 presidential election to 60 in the 2016 election. In Georgia, the number of polling places in predominantly Black counties was reduced by hundreds between 2012 and 2016. In the same period, more than 2 million voters were purged from voter rolls in states that had been subject to preclearance, in purges that were later found by federal courts to have violated the Voting Rights Act's remaining provisions by removing eligible voters without adequate notice or opportunity to contest the removal. These are not hypothetical harms. They are documented reductions in voting access that occurred in specific jurisdictions, affecting specific voters, as a direct consequence of the removal of the preclearance requirement that had previously blocked these changes. The response to these documented harms has been primarily through litigation under the remaining provisions of the Voting Rights Act, an exhausting and expensive process that produces remedies years after the harm has occurred, often after elections have already been decided under the discriminatory rules. This is exactly the problem that the preclearance requirement was designed to prevent, requiring the government to demonstrate harm after the fact rather than preventing discriminatory changes before they are implemented. The restoration of effective preclearance through the John Lewis Voting Rights Advancement Act would address this problem. The Act's passage has been blocked in the Senate. The polling places that were closed remain closed. The voters who were purged have in many cases not been restored to the rolls, and the elections that were held under the discriminatory rules have been certified and their results stand. This is the gap between the formal right to vote and the actual exercise of that right, measured in polling places, in purged voter rolls, in wait times, in the specific elections that were decided by electorates that were less representative than they should have been because the enforcement mechanism that was supposed to ensure representative participation had been removed, from the Edmund Pettus Bridge in 1965, to the Voting Rights Act that was signed 5 months later, to the Shelby County decision that gutted the preclearance requirement, to the 1,600 polling places closed in formerly covered jurisdictions, to the John Lewis Voting Rights Advancement Act that has not yet passed. That is where this history stands. The marchers crossed the bridge, the law was passed, the enforcement was weakened, and the work of ensuring that the formal right to vote is an actual right for all eligible citizens continues. Subscribe if this kind of history is what you are here for. There is a great deal more of it ahead. The last question this history raises is also its most important. It is the question of what a democracy actually is, and whether a democracy can call itself one if significant numbers of its eligible citizens face systematic barriers to exercising the right that defines democratic participation. The American answer to this question has been contested throughout the country's history. The founders who declared that all men are created equal while enslaving millions were giving one answer. The Reconstruction Congress that ratified the 15th Amendment was giving a different answer. The southern states that developed systematic disenfranchisement for 95 years were giving yet another answer. The civil rights movement that marched across the Edmund Pettus Bridge was demanding that the country live up to its stated answer. The Voting Rights Act was the federal government's most explicit commitment to the democratic answer, that the right to vote is not enough on its own, that active enforcement of that right is necessary, and that the federal government has both the authority and the obligation to provide that enforcement. The Shelby County decision and the contemporary restrictions on voting access represent a different answer. that the formal existence of the right is sufficient, that active enforcement is an overreach, and that the administrative decisions of state and local officials are entitled to deference even when those decisions reduce participation in specific communities. These are the two answers that American democracy has been giving for 60 years since the Voting Rights Act was passed, and the oscillation between them is the current state of the ongoing struggle over voting rights. Which answer prevails will determine what American democracy looks like for the next generation of voters. It will determine whether the marchers who crossed the Edmund Pettus Bridge in 1965 won a lasting victory or a temporary one. And it will determine whether the formal right to vote that every American citizen holds is a right that can actually be exercised or a promise that requires constant vigilance to defend. That is the question the history leaves open. And it is being answered right now in the courts and in the legislatures and in the elections that are shaped by the voting rules that are currently in place. Subscribe if you want to keep following this kind of history. There is more ahead.